Alexis, I saw you MG meeting with Steph.
Yeah.
How did it go?
I think it was fine. She interviewed last week, so.
Do you know if she's heard yet?
I don't know if they've heard yet or not.
Who else interviewed?
They're like, I like the recruiter Brian gave, but I don't know if she's on top of her shit. Because they did the first round of pledge last night.
Yeah. Whereas like our year they did the scholarship much
I didn't go
earlier.
through pledge at all.
Yeah, I know. So it kind of.
So kind of, well, and like, who else? You're like both, and who's waiting? You know, you're like waiting, and then how?
Yeah, Steph was like freaking out. I was like, just like stay with pledge, and then if you hear like something, like obviously
and withdraw.
Right, and like the pledge rose under a year, and then the scholarship was late and stuff. So they should do it earlier.
Yeah,
because that's like one of the benefits. You know, then you get like
the
firm gets who you want because they haven't already. Because like right now. They've already gotten their callbacks for pledge. Like they already know what firms they're interviewing with. So someone could potentially be like, oh, I really like this firm, even though like I have the scholarship and stuff. So
yeah.
I'm glad I'm not now. It was like such a
Remember how stressful that was?
Yeah, it was so stressful.
I know. I remember like. I wonder if I did it all. Like, I don't know, because I remember I cared about like everything so much. And you're like constantly comparing yourself to everyone else. It's nice to not feel that way.
Yeah.
So, yeah. So she's heard. Did she get good pledge?
I don't know. I actually just ran into
Dr.
another
Judge
one
Jones
else just
this
now.
way.
She told me she
Yes.
got really good
And,
pledges, but
yeah,
I
he's
don't know
flexible.
who's set.
Okay.
And
Okay.
he'll do whatever
I think
they,
she
and he was wondering if we want to meet him.
Yeah, she says.
Judge Arguello was down at the federal court, right? Who we meet with on March 11th?
Monica Marquez, Justice Marquez.
Oh, Marquez, sorry.
At the state Supreme Court.
Oh, states, oh, so I don't know whether.
No, that's okay.
Yeah.
Well, yeah, he suggested meeting at the courthouse, but if we've already been down
I
there.
like sat on a panel.
Should I
with
just-
someone
he said
else
coming
for
here is fine,
the
too,
and
it's on his
like,
way
always
home.
one else came up after me.
Well,
Always,
and does he
like,
teach?
one
Did
else
we talk about this?
came up,
Yeah,
I
he
have all these
teaches Tuesday,
interviews, what do I do?
Thursday.
And I was like,
Otherwise,
look at
it would
people's names. Like,
Same class into
Yeah.
four.
Well, anybody who.
He's pretty
Who
flexible.
else is
Okay, okay.
student this year?
pledge. Yeah.
A syllabus upstairs. Well, I'm gonna go upstairs and get copies of the briefs for you guys in a little bit. And when I do that, I'll get my syllabus and let's just pick a date.
Okay.
Yeah, but I think that makes sense. We'll stay here just to save
Do you know
transit
what
time.
Yeah,
Okay.
that's fine.
He's
That's
the
great.
one-
Thank you so much for doing that.
He
Yeah.
interviewed with HR.
He interviewed with
Or Brandon.
He's doing pledge too.
Oh, okay.
He's on a drug that's on team.
Oh, cool.
So he didn't say. I just saw him and he didn't say anything. So
I know, I never want to ask.
I know.
I'm like,
yeah. You want to be like, oh, so I heard you figure it out. Like,
yeah, I know.
what?
Yeah.
Can I see phone again?
Yeah.
Well, yeah, it looks, that's interesting. Yeah, she was in the same volume. Finding one.
Do you send them out to like judges and stuff?
You're supposed to. I'm actually going to send this to the Supreme Court.
Uh-huh.
So I will check the copies before I do that.
Right,
But yeah, you're supposed to, if you're really doing the right thing, you're supposed to send it to all your colleagues and
Yeah.
let them know what you've published. But
So now we all know to check before sending anything out. The Supreme Court's like, well, this domestic violence is interesting, but it's not really about Animus.
oh my god. Oh, crazy, crazy, crazy. Okay, so Bill, where's Bill? Allison can't be here.
Saw Bill in the building earlier today.
All right, well, we shall see. Okay, so
Apparently the roads are horrible, so.
I mean, I didn't
I know it's so tired. I'm so excited because I'm going to ski this weekend.
Oh,
Super happy.
nice.
Yeah. All right, well, let's just go ahead and get started. And the idea, we have a couple of these writing workshops, and the idea is that we can get some work done, but also be in the room and have conversations with each other, and I'll come around and talk to each of you individually about what you're doing. But this is a great starting point. anytime you're drafting, especially an appellate decision, is to outline, first we're going to outline, then draft it in sort of narrative form, the lower court decisions. And because it really gets you situated in the case and the issues in the case. And ultimately as an appellate court, when you're sitting as an appellate court, you're not relitigating the case, you're not rehearing the case, you're looking for error on the part of the lower courts, right? And of course here it's a little different because it's less a matter of error in a sense. I mean, it could be a matter of error, but it's also a matter of which approach the Supreme Court wants to take to deciding the issue in the Perry case. So the considerations I wanted to flag for you all, first is a level of detail. What sort of trade-offs do you think are involved in that decision? Is that something you typically think about ahead of time, or would you just start writing?
I usually, well, when I've interned, not usually, but I write the facts last.
The facts, okay, so underlying or procedural?
Both.
Okay.
I'll usually write, do the rule explanation, that part.
Yeah.
And then write the facts later, because then you know what facts you're emphasizing and what facts are important.
Okay. So that's an interesting
obviously
point.
I've done small ones.
Yeah, so that's an interesting point here. So I'm going to encourage you guys in terms of the underlying facts to keep that pretty. I mean, there's a lot you can say about the history of marriage in California, and maybe you will, want to talk about it at greater length, but that could be sort of a lot to wade through. But in terms of the procedural facts, really just talking about how the case proceeded through the district court and the Ninth Circuit, and in this case, because there's no special procedural issue, really just to focus on the reasoning of the courts in those two cases. And so I think you raise a good point, which is that those other questions about level of detail, characterization, emphasis, you might not really know where you stand on that until later in the drafting process, but I would encourage you then to at least draft maybe even just a more neutral description at a sort of mid-level detail of the two lower court decisions as foundation for starting to think about the case and how you want to approach the problem in your resolution of the case. So that being said, this is probably true for all of it. There's going to be change through the drafting process, right? There's going to be modification of the emphasis, the tone, whatever level of detail in the case description or in the description of the underlying decision as you go on. But so these still at the outset, level of detail. What are some of the considerations that might come into play there? What are the options in terms of level of detail in describing the district court and the Ninth Circuit decisions?
For each of them?
Sure, or just as a general proposition, whatever.
I mean, like on a continuum, it would be really specific or very general.
Okay. So like worst case scenarios, you're virtually, doing a line by line summary, right, or something like that. And then, in terms of being too general, like what would be too general?
They held in favor.
Yeah, maybe just stay in the holding or something like that, right? So obviously there's a lot of room in the middle there, but with too much detail, it just becomes too burdensome, right? And you're not really doing a service to the reader in terms of boiling down what happened in the case. But without sufficient detail, and maybe, if you really don't care what the lower courts did, maybe you don't want to have a lot of detail there. But I think it's kind of, whatever you ultimately decide doing, I think it's a really good exercise to do a description of the two cases and the sort of, like I said, a mid-level of detail. The other thing to think about is characterization. Do you want to present it sort of neutrally, or do you want to, characterize the district court opinion as very thorough and conservative, and the Ninth Circuit just went out, on a limb into this crazy theory, right? I mean, do you want to somehow characterize the two decisions either in a positive way or a negative way? And again, toward the end of supporting your ultimate resolution of the case. And then finally, the idea of emphasis. I think this is, as a writing skill and also an analytical skill, a really good thing to practice. What is the gist of each decision. Okay? And actually what I would like for you guys to do right now is take about 5 minutes and try to write one non-run-on sentence that kind of presents the gist or the essence of the district court decision and the Ninth Circuit decision. It's not to say this is going to be in your opinion at the end of the day. It's not to say it's going to be perfect. But make an effort at, what would I want to be my first sentence in this description that sets out what I think is important about each of these decisions and what they add to the case. Okay? Is that project clear? Okay, so go ahead and work on that. I'm making copies of the opening brief in the Perry case, and so I'm going to grab those from you guys. And I was supposed to get something else. The syllabus, so we can figure out when Judge Jones comes, okay?
Judge Jones from the Colorado Court of Appeals?
Mm-hmm.
What's the gist of the district court's opinion and the gist of the Ninth Circuit's opinion?
Okay. Oh, God, I still don't want to do that. Just feel like this isn't helpful because I still haven't decided, I haven't decided how we're going to write about this, or I'm going to write about this.
Yeah, so how would you characterize? I was thinking
Well,
about
because
that too.
I like have an idea of how I want to do it, but I mean, it's going to be way different if I, not really happy about this.
I've decided I'm going to write a deep rationalization of unconstitutional animus.
I'm going for that video.
Y'all get that was my understanding.
That's my understanding. That's what I'm saying.
Like this paper, I just thought you already turned in there.
The bar should my free first.
Oh my God.
And the bar is what, 6 days for whatever we take.
Yeah.
The other day when Kira shamed a poor bar failure.
I know. I also have a story about you that I forgot to tell you. I saw John Galligan and his hair was like all messed up and I was like, you look like you just woke up from hibernation, and he goes, yeah, I just slept with Bill Reed in the library. And I was like, wait a minute, that sounds weird. He was sleeping and I slept next to him. And so,
I love that guy.
Where do you sleep in the library?
Just in the no tech room.
Oh, just in the no tech room. It's my regular sleeping
Where everybody
spot.
sleeps.
Yeah.
I always thought there was like, on the first floor, how there's those chairs, like in the nooks by the.
Yeah.
Those always look like they'd be a good spot to
The
sleep.
problem with those is they have the seats out in the forum that are like right
right
next
there,
to
someone's
you.
like trying to just away from you through the glass.
You're like drooling a little.
That's what I would do.
They should just put like cotton those chairs are already like 3/4 of the way there. They
Yeah.
must have been full.
John was sprawled out on the couch in there. He just laid all the way down on the couch.
He's funny.
He is funny. And when we started, were we talking about this? When we started law school, I was thinking, no way this kid's gonna make it. But he's totally smart. He's great.
Did you start out evening?
Yeah.
Oh.
He was like 21.
Yeah.
Oh, really?
All
Yeah.
watching like over 30, about 30.
Oh my God. I
He's
didn't
with
know.
all these old people, you know.
He has a job and stuff too.
Yeah, he's already in PD. And no, he's done great.
Thank you, Miss Little Johnny, no job.
Johnny No Job, that's what we call it.
I love all your evening program nicknames.
Because everybody had like full-time
What?
jobs, that
Oh,
just
and
be
he was
hanging
drunk
around
as
all
well.
day.
Yeah.
He just like woke up
Like,
at
what-
5 and rolls into class and goes on.
Wait, he's an evening student?
The first
Yeah.
year.
He
yeah.
was?
So he applied really late, and then he said, well, you can come if you do the evening program.
That's great. I can just sleep all day and play video games.
Yeah.
Well, I was like, Bill has an excuse to be sitting in the library. He like has kids and stuff. And John was like, I have kids and you met my roommates.
I'm sure John gets less sleep than I do.
Can we just type up like the conclusion?
I'm like typing up these headings.
We're supposed to find the essence. Yeah, we find the essence of kids.
It's not in the table of contents.
Let's search for it.
I couldn't even get the basic elements when she made me write on the board.
No, you're just good. You gotta do it.
I think she'll encourage pretty much anything, yeah.
I made the mistake of like making eye contact. All right, you go up.
I gotta have something here.
How's it going? This cake. Is anyone gonna see Allison on Thursday or Friday? Okay, I'll just hang on to her copy. So this is the opening brief.
And the other one came, did you say it's coming out?
I think it's due Friday. Yeah, the 22nd. So,
I actually have, I know people who have class with her tomorrow, so I could take hers.
are you sure?
Yeah.
Okay.
Yeah.
Okay, thanks. Great, thank you.
You're welcome.
So really, yeah, we're probably gonna talk about the briefs on Monday. So I'll make sure, I mean, you guys can obviously find the briefs yourselves, but at least we'll wanna talk about the, appellant's brief on Monday. And maybe the appellee's brief on Wednesday.
So read this one.
Yeah. There's a zillion amicus briefs, I was sort of perusing them, but, interesting. I mean, you know, I don't know how the Supreme Court operates, if they have like one law clerk and they say, look at all the amicus briefs and see if there's anything useful here, or what have you. You know, when I was at the Vermont Supreme Court and we'd have big controversial issues, when we had same-sex marriage or civil unions when I was there were a lot of amicus briefs, but it was sort of, most of them were just kind of self-serving, you know, so it's really a matter of whether they say anything that's useful or not. And so if you guys want to look at amicus briefs, you're free to. I just, you know, I wouldn't make it a, you know, central part of your effort in drafting your decision. Okay, so, and then just real quick on schedule again. Looks like Alex and Kevin are going to come on April 8th.
Alex Hart?
Yes.
And Kevin McCown?
Yeah.
And when?
April 8th. So I'm thinking, well, how about April 15th, tax day?
Cool.
For Judge Jones? Great. And I'm on April 17th, we'll review this when we get there, but I actually have to be in California that day, so we're gonna not have class that day. Or maybe if you guys wanna have a guest speaker without me, but I kinda don't wanna miss any guest speakers, so. Okay.
On when?
April 17th.
7th.
Yeah.
Calendar.
So we might just make that, you know, because we don't have class, the weeks that we have individual conferences, we don't have class sessions, so we might just flip that. Any questions, any questions about the schedule?
I don't think so. Justice Marquez was March.
Yes.
Alex Harp, I met. Kevin.
Judge of Wales clerk, and she clerked, or he clerked for Judge Webb.
They're both super agreeable.
They're very nice.
And the other thing I just want to throw out to you guys, the last day of class, April 29th, Monday, I was tasked with creating a model syllabus for this course so that other people can teach it in the future. And so I actually would love to talk with you guys on that last day of class about kind of, you know, what might go in there and especially what problem, you know, if future classes would want to work on this problem, you know, the court will have reached a decision or maybe we pick a different problem. Okay. Any questions about the schedule? Just, you know, you can just bring them up, whatever. So any luck with writing your sentence? No. Okay, well, since you get the only sort of affirmative response, why don't you go ahead and start?
That's the opposite of an affirmative.
It's affirmative in the sense of, you know, you were an agent in expressing something.
The district court, I have Prop 8 fails rational basis review because. And then the Ninth Circuit.
Well, I'm going to give you a great hint. I'll do a lot. Start the sentence with the district court.
Okay.
Because what you really want to do is characterize what the court did as opposed to, right, it's holding. I mean, you could, you know, your first sentence could be, the district court made extensive findings of fact. You know, your first sentence could be, the district court ultimately determined to apply rational basis review despite finding that sexual orientation was a suspect classification. Actually, let's write something you guys don't mind. We'll just brainstorm a little bit. I mean, why would you say one thing versus the other? Okay, so if you said the district court made extensive findings of fact after, you know, following a, whatever it was, 11-day trial, why might the Supreme Court want to talk about the district court this way? Where might the Supreme Court be going if it talks about the district court this way?
In their direction?
Maybe reviving some of those factual findings, right? I mean, that's not the only reason that the court might say it like that, but. And then the court, of course, would have to deal with what issue that the Ninth Circuit sort of dodged?
The adjudicator versus legislator.
Yeah. Okay. So, but if the court wanted to make more use of those really extensive factual findings, this is something the court might do. And again, you're not going to necessarily decide this down, but I want you to make some tentative efforts of this characterization and then see, you know, kind of how that plays out. Okay, you know, if you want to talk about, if you want to allude to the fact that the court conducted the suspect classification analysis, you know, maybe the court then would be looking at suspect classification analysis. Okay, do you guys want a couple more minutes? Or you want to talk some more? Go ahead, Bill. So you breathe, that's enough in this classroom. Yeah.
I was just thinking more about the second one. I was copying more stuff down, so I wasn't.
Oh, sure.
I wasn't processing that.
Does anyone else want to share? Do you want to share your second sentence, Phil?
The second one, I thought the exercise was to try to get kind of the essence of what
gotcha.
we're talking about. So,
Go ahead.
So with Ninth Circuit, I wanted to get the whole given and taken away thing. So I was thinking something like, it fails rational basis review because a right was given and then taken away for the sole purpose of expressing disapproval of a discrete group.
Okay, good. Yeah, and that's just what the Ninth Circuit held. I mean, that's fine. Or, the core of the Ninth Circuit's reasoning was this. That's totally appropriate. Will?
For district court, I threw in there, Proposition 8's denial of licensing gay and lesbian marriages lacks any rational basis and is a violation of the equal protection and due process clauses of under the 14th Amendment.
Okay. So that's very literal. I don't know, it doesn't tip your hand in terms of where you're going to go with that, right? So in terms of the characterization piece, it's a little light on characterization, which may ultimately be fun. You may want to be neutral. So let's put down some of the qualities again. So things you could focus on: extensive findings of fact, suspect classification analysis, and you said both due process and equal protection. That might be something that I would seize onto from the way you characterize the district court decision. Which, might be important to mention if the court wants to go in a due process direction, right? This was, both of these were addressed by the district court. Because the district court, I think, did a really nice job on the due process analysis.
And then it seemed like that circuit almost kind of dropped off a lot of the due process too.
Yes.
In their analysis.
No, they did, yeah. Yeah. But that's all, they're still there in the record, right? So, that's a direction the court could decide to go in. Ninth Circuit, Bill, you mentioned sort of taking away rights expresses what?
They were taking away rights for the sole purpose of expressing disapproval.
And yeah, and so the Supreme Court, if it characterized the Ninth Circuit that way, it might be saying, that's the direction we're going to go in. But the court could say, this is the path we're going to follow. This is way too narrow, to make it so dependent on the taking away. Or, this is unsupported by precedent. The idea that this is impermissible, this you can't, the ratcheting up or ratcheting down effect, however they described it. Your head pointing at the Ninth Circuit? No?
No, not quite as good or complete. But yeah, they definitely construed it to looking at it narrowly. That it's just removal of once a state right that was once removed.
Yeah, okay.
Is the true violation of an equal protection.
So, but just the first word that popped out of your mouth there too, there's a difference between describing substantively the Ninth Circuit really focused on this idea of taking away rights and saying the Ninth Circuit's decision was exceedingly narrow, right? They're both kind of getting the same thing, but from a different level. And both would be interesting ways of starting the discussion about those decisions. Kara?
My district court one was the evidence presented at trial demonstrates that Prop 8 does not advance any legitimate interest unless fails rational basis. So I was trying to get at the extensive findings of fact.
Right, and so you can put this more on the level of literal description or more on the level of meta-commentary. When you make it literal description, it's kind of more forceful because you're saying, well, this is what happened. This is the evidence presented at trial established X, Y, and Z. Versus when you make a sort of meta description, it almost reveals it more as strategy by the trial court. So that's, these two kind of get the same thing, but with different rhetorical effects, I think. What about the Ninth Circuit?
I didn't write anything out, but what I was thinking about was the taking away. That
Uh-huh.
was the gist to me.
Good, no, that's good. No, I think, but that's accurate. You know, Alexis?
I said that the district court issued a permanent injunction against California's Proposition 8 because it, one, violated plaintiff's fundamental right to marriage under the 14th Amendment's right to due process.
Did I say something about run-on sentences?
Yeah, this is totally a
No, that's fine.
And
So-
two, violated their equal protection rights
Okay.
because it's not rationally related to any governmental interest.
Okay. So that's really, again, coming back to the sort of two bases. Good.
And then the Ninth Circuit upheld the district court's injunction because Proposition 8's taking away of a previously granted right to marriage for same-sex couples was not rationally related to any governmental interest.
Okay, okay. So again, what we see here is a spectrum in terms of, right, whether you're kind of being more literal or more meta about it, a spectrum in terms of being, having more characterization involved versus just the facts man kind of saying, well, this is what the court held. So just consider those trade-offs as you go forward with this drafting process. Now what I want you guys to do, is to, whether it's on paper or in in your document, I like to build whatever I'm writing all in one document, just like notes and everything kind of, I'll put in there together, but do whatever you're comfortable with. A functional outline of these two decisions, okay? So the functional outline, we want to start on kind of a broad level, so I'd like to get, hopefully you can cover both of the decisions today, but the functional level would be, describe what the court did. So the district court presented findings of fact, and then you could say, RE, and then the categories of findings of fact. The court then addressed whether there's a due process violation. Okay. So we're looking at 3, 5 sort of headings, and then go back and start disaggregating within that. Okay, so within the due process analysis, the court first considered what exactly the fundamental right of marriage entailed and whether that was implicated here. Okay, but do the sort of, 3 to 5, whatever main functional components, they're probably marked off by Roman numerals, for the two decisions. And then we'll go deeper into that. Does that make sense? And do you guys understand why we're doing this? Oh, look at this.
What does that say the court then addressed?
Whether there was a due process violation, or however you want to phrase it. I mean, there are multiple different ways to phrase it. So this is what I do, is I scoot my chair around. So.
I just get the findings back from it.
Yeah, no, I think that makes sense.
I was just going into the process of marriages and unmarried. That's a perfect.
Okay.
So that is the reason why.
Yeah, and just try, one thing I would say, you don't have to do it this way, but try just doing the big headings for both.
Okay.
And then
And then
going back
going
and
down.
putting the detail there. Perfect, yeah.
Like in a really high level.
Yeah, no, that's right, that's good.
Okay.
Because you want to understand the relationship between the high level and the detail level, right? Okay, good. And then, okay, so then we're going to
Yeah, awesome.
Follow mostly just their headings.
see, that's pretty easy, right?
Yeah, and then, but yeah, under each one of these, there's definitely a lot of different subheadings, which actually provide a lot of context. and
Yeah.
supportiness.
Okay.
And then also the standards of review.
Yeah.
And the analysis will go over each of these.
Perfect.
How much, for like the credibility determinations, and how important is it to be if who was witnessing?
Well, so you don't know now, right? So basically, when you think about the district court's decision here, you have this really full portrait of all the factual findings in the case, and you're really going to want to go in and pick and choose, if you even end up really caring about any of those factual findings, but your analysis might not depend on that.
Okay.
But if you want to look at whether there's a due process violation as the Supreme Court, or if you want to look at whether sexual orientation is assessed by classification, you are going to be relying on the district court's findings. And so the credibility determinations are not, essentially not reviewable, right? But they're just there.
That's stuff at the district
Yeah,
level.
exactly. But in terms of picking and choosing among the findings of fact, I would leave that very general right now, because you're only going to know which ones you're interested in after you develop your legal argument a little bit.
Okay.
Okay? Good.
And so from like our opinions, we're probably going to just continue to probably just narrow the focus a little bit too about which legal analysis we're gonna tackle.
Yeah, I mean, we'll review maybe at the end of this session the sort of various paths that you can take, but you can basically take one issue and write it all the way to the end, or you can look at multiple issues and dispense with them and then go to the dispositive issue. So it kind of depends on the approach, and it's also a strategic decision on the part of the court whether they want to say we're just going to tackle this dispositive issue, or whether they want to address the arguments. Okay, now the hard part starts, right? Okay, so yeah, you guys have got that sort of big picture thing going, and now, you don't have to develop each part into the same level of detail, but start tackling what are the main points in reasoning around the due process claim, around the suspect classification analysis, et cetera. reading my own writing, I tend to vocalize a little bit more.
Because
The
they,
appellate court's versus-
well, because they kind of say like, we start talking about district court's opinion and then you're like, but we're not going to talk about that.
Yeah.
And then, so.
Well, that's good. That makes you really focus on, well, what is the function, you know? I mean, is it kind of a throwaway passage, maybe? And then the whole section on Romer, you know, and the Ninth Circuit decision, the whole section on Romer, trying to figure out what is the court doing there? Why is it talking about Romer, to what end, sort of functionally in advancing the analysis? Do you have any questions?
No.
Okay. Okay.
So I'm doing the Ninth Circuit too, I'm kind of in the whole Roma taking away, I mean, it's not as clean as the district.
Uh-huh. And yeah, to the extent you guys are kind of struggling with, well, how do we phrase this, or that's exactly the struggle you're supposed to be having, because it's making you really think about.
I have a question.
Yes, of course.
Did the Ninth Circuit certify the question, the federal district court, didn't the Ninth Circuit do it?
The standing question?
Yeah.
I believe that's correct. Let me look at the docket and try to figure that out, but it was in the Ninth Circuit when the standing question came up. So,
So for in the district court, Walker just.
well, because Schwarzenegger was still defending
Oh.
through the district
okay.
court
But
level.
then
And that's, I
Brown
think,
applied.
yeah, so what exactly, I think Brown, it was sometime after the appeal was
Okay.
accepted, because the caption is still Perry versus Brown. So that must have been, but let me see if I can figure out the timing of it.
Okay.
Yeah.
Thanks.
Because it was, Reinhardt said something about, like, delayed our decision, this action.
They had a whole, yeah, they had a
Waiting
whole
for the-
separate round of briefing and everything.
There was like a 9-month window or something,
Yeah.
just doing that.
Yeah, yeah.
I'm still kind of hashing out the district court case,
Yeah,
but I
that's
think this is going to be part of my basis, and then even Ninth Circuit as well, I can see their take on these, and then probably focus on one of these two issues.
Cool.
I don't think we'll go too far into the suspect class, but
It's really messy,
yeah.
but interesting, definitely interesting, and we can, yeah.
It's almost like a whole development of a whole new, establishing a whole new class, which I don't know if it's important really going to do that.
You know, most people think, not most people, many people, you know, basically talked about Bill Eskridge and Kenji Yoshino, you know. Bill Eskridge is like, you know, historical pattern, civil rights movement, feminist movement, you get to a certain point and then there's a trigger and the court recognizes you as a suspect or quasi-suspect class. And he's like, the exact same thing is happening here. The court's going to recognize sexual orientation as a suspect class in the context of deciding marriage equality. And Kenji Yoshino, you know, the general proposition is saying, you know, the court's done. The court's done with this. It's, you know, this article I'm writing right now is about sort of the history of suspect classification analysis and the way that it developed through the cases, and it's really irrational and bizarre. But basically the court, so Carolyn Products was decided in 1938, and you have that law clerk drafted footnote that says, oh, well, these are things that we think about for heightened scrutiny. And then you have Korematsu in 1944. It doesn't really, you know, do much in terms of a suspect classification analysis. It doesn't cite Caroline products. And then you have Graham, I want to say in 1971, and the court's like, okay, we're going to actually we're going to do a suspect classification analysis based on Caroline products. By 1973, in San Antonio School District versus Rodriguez, the court's like, well, these are the traditional indicia of suspectness, right? So really, it essentially is going from 1971 to 1973, saying that this is a traditional test all of a sudden. And then 1977 is the last new suspect or quasi-suspect class that the court has recognized. So it's this kind of incredibly compressed window of time, you know, in which this all happened. So, yeah, I don't see the court doing it. I don't see the court doing it. I think the court's going to decide the DOMA case on just rational basis and say, you know, the federal government has no business trying to define marriage. It's never had any business doing that.
Yeah.
And I think Prop 8, I wanted to turn on Animus, obviously, because that's what I write about, but I just don't know.
What does Dallas Ridge think? They'll say it's intermediate scrutiny or strict scrutiny?
You know, I didn't ask him about that in particular, but I think logically it would be strict scrutiny, right? I mean, there's this whole weird thing with gender as a suspect class, right? Where first it was like, oh yeah, it's strict scrutiny, it's just like everything else, and then you have this idea that there are real differences between men and women, which I think kind of reflects this like certain moment in the feminist movement, you know, of trying to deal with those issues. But you know, the idea of, I mean, I think it's probably arguably correct that gender might properly be considered by a legislature under some circumstances. Whereas unless you're regulating sexuality, which the state should not be in the business of doing outside of harmed individuals, it's really hard to see how sexual orientation is a valid classification for legislatures to use. I mean, that's all my stuff. I mean, that's, you know, you guys obviously, you're free to have whatever views you want. This is just kind of what I've been thinking about and how I've been thinking about it. But
how does Kendi Yoshino think the court's going to deal
well, so he hasn't talked about, okay, so he has actually an interesting blog post on his SCOTUS blog where he talks about the different paths the court might take. And I'm trying to think, so he was talking about, because his article on the new equal protection was not really in the context of same-sex marriage, right? But he's sort of like, basically, we have to look at the fundamental rights prong of equal protection analysis because the classification thing is done. It's not going to work for people anymore. He talks about pluralism anxiety, right? Like there's just too many groups, and what if we start recognizing all of them? And it's interesting because when you go back to cases in the 1970s, especially like the gender cases, it's this free-for-all. It's like, yeah, that's a suspect class, why not? You know, and it's really a change in tone, I think, as between the cases recognizing the new suspect classes and quasi-suspect classes, and then the cases kind of clamping down and saying, no, we can't extend this protection here. But so on his SCOTUS blog piece, I think his prediction was, so either they're going to go on the standing issue, which I don't think flies in Prop 8. I think that's maybe flies in DOMA. Or the taking away rights is Animus, that sort of narrow issue. And he looked at some broader arguments too, but I don't think one of them was suspect classification. But I have to look back at the article.
So then if they do taking away rights as Animus, then they'll have to just do the next state challenge totally from scratch.
Yep. It'll be a very narrow decision.
I mean, could they pursue due process and look at like marriages,
Yes.
right?
Yeah.
I mean, even though that wasn't much of a discussion in that circuit.
Doesn't matter. Yeah.
Okay.
I mean, yeah, we'll have to look at the Appellee's brief and see. I would be shocked if they didn't raise it in their briefs.
Okay.
And again, the court could affirm on that basis.
Right.
I wonder why the Supreme Court granted cert on the Prop 8 when it's so narrow, when they could have just granted cert on another one.
Well, also think about it. I mean, who wants to grant cert on it? And why?
Who on the court?
I mean, it seems like if you go violation of due process too, like you have a fundamental right for marriage, I mean, wouldn't it almost remove like the other DOMA cases and everything too? So it's hard to say that that's to go into like the Animus as far as taking away taking.
Do you guys want to go ahead and start mapping some of this out? I don't want to interfere with your workshop time, but I think since we're talking about it, there are routes the court could take that will have an impact on all other marriage litigation, and routes the court could take. I mean, DOMA is singular, right? I mean, if DOMA is unconstitutional on its face, it's unconstitutional on its face. And that, and I'm pretty sure, I know the folks in the Jackson litigation, which is not a DOMA case, it's a state case, but other marriage equality challenges have been stayed in the meantime, right, to see what happens in these cases.
Right.
Okay, so Defense of Marriage Act.
Do we know how many there are?
How many total cases?
Yeah. How many states have raised?
I could assemble that information from you.
Just
There's
the best guess is all kind of.
how much litigation is going on?
Yeah. I mean, is this one that's like?
I mean, I want to say there's at least like a half dozen
Okay.
state challenges in court right now. There's one so there's Hawaii, that's in federal court, but it's a challenge to state law. There's one in New Jersey. Arizona, I think a few other places, but I'm not 100%.
Okay.
Okay, so Defense of Marriage Act, let's say the court just says no rational basis. That will, in the sort of traditional sense of it's just not justified, not an animus issue or anything else, right? There's just no reason for the federal government to be doing this. That would affect the DOMA cases, and it would not affect the state law cases, right? Because it's just the states participating in the regulation of marriage is just fundamentally different than the federal government participating in the regulation of marriage. Okay, and one of the ideas here. Ooh, I spelled that. States are the laboratory of democracy, right? And we should let states either decide on their own that they want to allow for same-sex marriage or they want to ban it. And the federal government shouldn't come in and interfere with that, okay? And this is, I think, an interesting theme if it comes up in this case, because that suggests that the states should be at liberty to decide when, if they want to recognize same-sex marriage. You know, DOMA, under my theory of unconstitutional animus, DOMA could be struck on the basis of animus because the legislative record essentially says we are passing this because we don't approve of same-sex marriage and of same-sex couples. But I don't think the court would go there. I don't think the court would go there if it didn't have to, and I don't think it has to. But if it said, you know, there's unconstitutional, I mean, there are myriad issues with animus, right? But if the court said, this law is based on animus as evidenced by statements in the legislative record, and that invalidates the entirety of the law, that can have very broad effects. Because if you had state law legislative enactments where there's a similar legislative record, or enactments through popular referendum that are based on statements of homophobia, that would potentially fall into this too. But the open questions with animus, you know, I talked about this in the article, but first of all, what's the definition of it? Not really clear. What counts as evidence of animus, and then what consequences of finding animus. Definition, is animus about hostility, or is it just something as simple as stereotype? You know, group stereotype. In terms of evidence, first of all, do you have to have this legislative history of some form or another with these clear statements? And is it, you know, one legislator? Is it the consensus? Is it the primary impetus? I mean, what's the test, right? And this all looks at animus as essentially a subjective intent. right? So it's passed because they don't like this group of people, and we need to discern, who was involved in the passing of the law, who felt that way. I made this argument that animus should be considered as a form of objective function of the law, so you don't have to go into the subjective intent inquiry. But I think most people like to think of animus as a subjective intent issue. And then consequences, the main issue with consequences is, can other legitimate state interests save the law once you find animus? Right? Or is animus a silver bullet? And I think I mentioned this before, the court, every time the court's found animus, it has found the law unconstitutional. But it seems to suggest that animus has to be the only basis for the law. So there are no other legitimate state interests. Then you have this whole kind of circular reasoning in Romer. Well, the absence of legitimate state interest is evidence of the presence of animus. The presence of animus makes us look more skeptically at the legitimate state interest. I mean, it's a mess, basically. So I think the court won't say anything about animus in the Doma case. If it did, these are the questions it's going to bring up. But the Doma decision, the Windsor decision, I think, has a chance to be extremely narrow.
What circuit is that coming from?
Sorry?
What circuit is?
Second Circuit. But there are multiple Doma challenges out there.
Yeah. Reinhardt's opinion had, it felt like he was, very careful to not be, calling anyone homophobic.
I know.
Yeah. He's like, it's okay, we can't,
Yeah.
endorse it as a state, but I thought that was interesting, that he spent that much time, saying that's not calling you homophobic.
Yeah, yeah. Well, and it's an important doctrinal matter too, So he's saying there, but see, this is what's interesting. I want to say, I talked to you guys about this Jackson case in the Hawaii District Court, I think. It's kind of like what I'm writing and what I'm talking about in classes all kind of mixing together. But the court there said, we don't have animus here because we never gave marriage rights to same-sex couples. So taking them away, it's not the same as it was in Perry. So Perry and the entire idea of animus off the table. Not looking at any other, and that's wrong. I don't think Perry was saying that that's the only form of animus, but it could be interpreted that way. And the First Circuit in Gill, if I'm remembering this correctly, struck down Doma, said it failed rational basis review, but did a similar thing and said, but we're not finding animus because we don't see any evidence of spite or hostility. So kind of really overstating that point, which is weird because I think Doma was pretty, it was pretty clear what was kind of going on there, but it was such a different time. And I think in general, the idea of the courts impugning the motives of either the populace or the legislative branch is kind of distasteful for people. But so how you understand animus, in turn, changes the meaning of saying that a law is based on animus. If animus is homophobia, that's kind of a loaded thing to say. If animus is just stereotype, disapproval, it's a little different. So with Perry, court could go straight to rational basis review only if it was going to affirm and say that Proposition 8 is unconstitutional, okay? And then that could be, again, no rational basis or animus. And then holding on animus could be narrow or broad. Narrow being this sort of taking away idea. It could look at it as a due process argument. And here the court would have to say both, would have to define the fundamental right to marriage, what that actually means, and what burdening means. Because, the court could say, if you have the full panoply of rights under a parallel system, that's not a burden on the right. And that's where, potentially like a separate but equal argument might come up. And then under equal protection, oh, and of course standing, guys, I'm sorry, I keep leaving that out. But again, because that's a matter of state law, conferring standing on the proponents, I think that's kind of off the table. In DOMA, it's on the table for sure. Like, of course, it can't be off the table. They asked for a briefing on it, but I see it as fundamentally different. So, under equal protection. Oh, the other thing I wanted to say about the due process route, and I'd be very interested, Will, if you want to write this route, or anybody else does, I'd really be interested in seeing it. This, this opens the door to challenge to polygamy laws, right? And other, consanguinity, whatever it happens to be. So I think this is really dangerous territory.
It seems like it would be pretty broad to go that route. As far as what you could do, and that seems to be opposite what the Supreme Court traditionally does.
Yeah, no, that's right. It's scary to talk about fundamental rights because you really open a can of worms there. And I think a lot of people have a strong intuitive feeling of it may be fair for same-sex couples to get married, but that's not part of the traditional idea of marriage. I don't know. So equal protection, it could be sex discrimination. This is my favorite argument. Or sexual orientation discrimination. Okay, the strongest argument that it's sex discrimination, it has to rely, it's exactly the same as the anti-miscegenation laws. It is prohibiting a combination of people within a couple by relying on facial sex classifications. So if it is, this would be the big argument though, is it sex discrimination? If it is, then you get intermediate scrutiny and probably it will fail. Intermediate scrutiny, but hard to say. And if the court is like, no, it's sexual orientation discrimination, which is not on the face of the law, you have to make an inference that people of particular orientation want to marry someone who fits that orientation, which is really a very romantic idea of marriage that I don't think is entirely true. Then the question is that a suspect or quasi-suspect classification? And in that context, what is the proper emphasis in suspect classification analysis? Is the proper emphasis on immutability, on political power, on relevance of the trait to ability to function in society? And then it'll be either intermediate scrutiny or strict scrutiny. And you can kind of see, I'm following into that pattern of, well, the big arguments are about what level of scrutiny, and then kind of assuming that if it's heightened scrutiny, the law will fail. And honestly, I think that's, once you get rid of moral disapproval as a permissible goal, it's a little rough in terms of offering the state interests. Here they're just saying, well, the Ninth Circuit was wrong because the timing doesn't matter, and the taking away sort of dynamic doesn't make it per se unconstitutional. Their state interests, it advances society's vital interest in responsible procreation and child rearing. The linkage between child rearing and marriage is pretty broken, right? The argument that they are encouraging heterosexuals to marry by keeping homosexuals out is kind of a Plessy versus Ferguson type argument. In a way, we're making this institution attractive by excluding this undesirable group. Yeah, weird. That proposition, well, this argument, this is poorly organized. The Proposition 8 did not eliminate domestic partnerships does not render it irrational. Okay, first of all, double negative. Secondly, not really about procreation and child rearing. But what they're saying there is, that was the other basis that Kenji talked about. That the Ninth Circuit sort of said, well, if you have all the incidents of marriage and domestic partnerships, and you're just keeping the title away, that's really about saying, that's a pure expression of these people don't deserve to be part of this institution. We recognize that they're similarly situated, but we're still treating them differently, which is separate but equal discrimination. So another narrow holding could be, it's only unconstitutional to deny the title of marriage to same-sex couples in states that otherwise grant the full panoply of rights, which then incentivizes states to not grant the full panoply of rights. You don't want to redefine a bedrock social institution. That sounds like just preserving tradition for the sake of tradition. Democratic authority, that really doesn't stand up in the face of the 14th Amendment. The 14th Amendment Equal Protection Clause is a counter-majoritarian tool. Proposition 8 does not dishonor gays and lesbians, and that kind of goes to the animus argument, which is, it's just to say that I do think proponents have a hard time under any form of heightened scrutiny. Either, even more so actually, under the tailoring prong. We talked about there's always the sufficiency of the state interest prong, and then the tailoring prong. So, under rational basis, so typically, and I'll stop after this, typically under rational basis review, the legislature or the proponents could just be like, we think that it's important to promote procreation, and we think by randomly excluding this group, it's going to help that. Traditional rational basis review, totally fine. Intermediate scrutiny or strict scrutiny, no. You have to show that it's actually, the burden is on the government to show that the law is actually accomplishing in some way this thing they say it's going to accomplish. So, it just further emphasizes that the choice of level of scrutiny and the characterization of rational basis review, which is a huge issue in this case potentially too, really is sort of outcome determinative.
Strict scrutiny is narrowly tailored?
Yeah.
And what's intermediate?
Substantially related. So again, plaintiffs generally win under either form of heightened scrutiny, though there are some immigration, an intersection of immigration issues and gender issues, where recent cases where plaintiffs have lost under intermediate scrutiny. But this is more traditionally in the intermediate scrutiny kind of realm. So, but this is basically, and I should put this up here. Is it the rational basis review of Heller or of Romer? Which would be, that'd be fascinating to talk about in one of your papers. It'd be fascinating if the court sort of tackles that. But so these are kind of your options, right? In terms of how you want to, and I do start thinking about what really appeals to you, and then kind of commit to that, because you don't want to try to talk through all of it. It's going to take you 3 years to write that. I mean, not really, but if one really addressed all the contingencies, it would be a very, 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 very long decision.
When we're doing the summary, if we find in the briefs, say there were 8 purposes they had in the district court and there are 4 they have now, do you bother summarizing stuff that's dropped off?
Well, so it depends. What does it depend on?
If you're gonna,
Partly depends on the level of scrutiny, because under rational basis review, the court can imagine. It can conjure up legitimate state interest for the law. So the court then can refer to anything. Under heightened scrutiny, I think the proponents would be limited to what they advance in their Supreme Court brief.
Those would be the only things.
I mean, again, it should be black and white, it's not actually, but that would be my contention.
So then you'd only summarize those. You wouldn't.
You don't, I mean, you know.
The summary isn't like this historical document. I mean, it's
No.
useful.
No, it's strategic. It's totally strategic. A lot of times the Supreme Court doesn't even talk about it because it's below. It doesn't care, right? So it really is strategic. But yeah, I wouldn't, so for example, in your current draft summary of the two decisions, flag, this is the section where